I'm A.G. Harmon of the Columbus School of Law at the Catholic University of America. And on behalf of the faculty, let me tell you how much we appreciate you for Zooming into today's last presentation in this year's Student Scholar Series. Please stay on mute until the presentation and response are over, and then I'll open the floor to questions, which you'll signal with your raise hand feature. This series was instituted in 2009 to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by third-year student I-Ching Chiu. Before I introduce I-Ching, a few words about her respondent, Daniel Kim. Mr. Kim is an associate in Dechert's National Security Group, where he advises clients on cross-border regulatory matters, including CFIRS reviews, economic sanctions, export controls, and related compliance issues. Prior to joining Dechert, he was an associate at Arnold & Porter in its Washington, D.C. office, and served as a trade fellow to Senator Tom Carper, where he advised on international economic and legislative policy. He received his JD from Columbia Law School, and he has worked in Division III, and we appreciate him for joining us in the program today. I'll now introduce our student scholar, I-Ching Chiu. I-Ching is a third-year law student here at Catholic. She serves as a note and comment editor on the Law Review and holds a master's and bachelor's in diplomacy from the National I-Ching Chiu University in Taiwan. Before law school, she worked in trade and economic policy for the Taiwanese government, and she expects to graduate in May of 2026 with a certificate in law and technology, hoping and expecting to work in the fields of international trade and on economic issues. She wrote her comment on the Outbound Investment Security Program to better understand the limits of IEEPA authority, a question that turned out to be timely as the Supreme Court struck down President Trump's IEEPA tariffs in February of 2026. Now I'll turn the floor over to I-Ching to present her scholarship on potential judicial review of legal authority of the Outbound Investment Security Program. All right, so let me now give I-Ching the hosting capabilities. I-Ching, take over.
Let me share my screen right now. Is everybody able to see my screen? Okay. Thank you, Professor Harmon, and good afternoon, everyone. I'm I-Ching Chiu, and my article is titled Potential Judicial Review of the Legal Authority of the Outbound Investment Security Program. So in August 2023, the Biden administration issued an executive order restricting the outbound investments of national securities technologies and products in certain countries of concern under the International Emergency Economic Powers Act, or IEEPA. To implement this order, the Department of Treasury published the Outbound Investment Security Program. And my article is to explore how this outbound program should be reviewed if challenged in court. After reviewing the history of investment screening, the statutory framework of IEEPA, and the relevant cases of procedural challenges, my article argues that for the outbound program, it should not be challenged substantively, like exceeding the authority granted by IEEPA. However, it proposes that the procedural due process grounds should remain available for a private party to challenge the process by which the outbound program is conducted especially those determinations by Treasury under the program. To provide some background, I will begin with a brief overview of investment screening. So the United States generally views foreign direct investment as a positive benefit for the US and globally. However, there were times when foreign investment transactions raised national security concerns. And this led to the establishment of the Committee on Foreign Investment in the United States, or CFIUS. CFIUS was established in 1975 by an executive order to review foreign investments coming into the US. It has been revamped through legislation and was codified in 2007. The Treasury Secretary chairs the CFIUS, and its members included the heads of 8 other departments and 2 non-voting members. The most recent legislation is FIRMA, Foreign Investment Risk Review Modernization Act. FIRMA expands the CFIUS jurisdiction and addresses national security concerns from transactions like real estate close to military sites or government facilities of national security sensitivities, as well as those investments in critical infrastructure or technologies which were previously outside the CFIUS jurisdiction. And the CFIUS review process under FIRMA has 3 steps. First, the parties files basic transaction information with CFIUS. This part is largely voluntary, but some are mandatory. Second, based on an initial assessment, CFIUS may conduct a 45-day national security review, applying Congress mandated factors. And if that review finds a threat to national security, foreign government control, or foreign control of critical infrastructure, a further 45-day national security investigation will be triggered. And at the conclusion of that investigation, CFIUS will submit a recommendation to the president, who may then block or suspend the investment, but the president is not bound by the recommendation by CFIUS. While CFIUS was established and a review process was created, it does not address the issue of outbound investment, meaning those investments from the US to other countries. Instead, a separate authority exists for the president to exercise emergency powers in times of unusual and extraordinary threat. That is IEEPA. And under IEEPA, the president can block new investments in certain foreign countries. Such measures could, in effect, restrict outbound investment, even though not in such a name. Most of the time, such measures are geographically specific, and it's imposed due to the concerns over the domestic situation of the destination countries, such as a violation of human rights. And more recently, there were legislative proposals on restrict outbound investments. They are not actually enacted, but they reflect how Congress saw the need to restrict outbound investments. In the 2021 proposal, it defined the national critical capabilities to include the production of medical supplies, critical infrastructure, and military or intelligence operations. And in 2023 proposal, it focused on the advanced semiconductors and microelectronics, artificial intelligence, and satellite-based communication. And against this backdrop of legislative proposals and the surrounding debate, President Biden issued an executive order in August 2023. Relying on IEEPA and other authorities, the president issued an order and declared a national emergency to deal with the threat to national security posed by the advancement of countries of concern in sensitive technologies. And the president also directed the Department of Treasury to issue regulations implementing this order. So in November 2024, the Treasury issued a final rule regarding the Outbound Investment Security Program, which was effective on January 2nd, 2025. Under the program, the covered transactions involve three sectors, that is, semiconductors and microelectronics, quantum information technologies, and artificial intelligence. And the programs lays out two types of obligation. The first type is those are subject to a notification. And the second type is those will be prohibited from engaging in certain transactions. And to note that the country of concern here, which is only include China at this time. And the final rule also provides certain accepted transactions and national interest exemptions from the two types of obligation if the Treasury determines that it is in the national interest of the United States to do so. With that background in place, I turn to how courts should review the substantive and procedural claims concerning the Outbound Investment Program. First, on substantive claims, I argue that the Outbound Program should not be overturned on the ground that it exceeds the statutory under IEEPA. So again, IEEPA is also the authority President Trump used to impose certain tariffs, but recently overruled by the Supreme Court. So enacted in 1977, IEEPA has been viewed as a delegation of emergency authority to the president. It grants the president powers to regulate a variety of economic transactions during a state of national emergency. It empowered the president to deal with any unusual and extraordinary threat originating outside the United States to national security, foreign policy, or economic of the United States if the president declares a national emergency with respect to such a threat. Specifically, the president is provided with the power to investigate, regulate, or prohibit specific economic transactions involving any property in which a foreign country or national has an interest. In other words, this authorization targets foreign interest. Next, I want to introduce how Supreme Court had reviewed the scope of authority in IEEPA in 1981 case, James and Moore versus Reagan. So after the hostage crisis in Iran, the president invoked IEEPA and terminated all legal proceedings against the Iranian government according to the agreement between the two countries. And Dems and Moore, the plaintiff here, attempted to recover over $3 million owed to it by the Iranian government and claimed that the executive actions were beyond the scope of presidential power granted by IEEPA. So regarding the two issues here, the court decided that IEEPA authorized the president to order the transfer of Iranian assets and find that although IEEPA did not authorize the president to suspend claims pending in American courts, but based on the previous act of Congress regarding claim settlement, the court find that it implicitly approved of executive control in the fact of this case. So eventually, the court rejected the challenge here, but emphasized the narrowness of this decision. Here is how IEEPA statutory framework is likely to play out in the Outbound program. So under IEEPA, the government may block or regulate transactions involving any property in which a foreign national has an interest, and such broad authority is upheld by the Supreme Court in Dems and Moore. And I argue that the Outbound program should not be overturned on the ground that is beyond statutory authority. And the counter-argument would be that IEEPA was enacted to reform emergency power under the Trading with Enemy Act, which granted the executive an extraordinary degree of control over issues between U.S. and its enemies. Therefore, the substance of the program, such an expensive use of IEEPA, would not be what Congress intended when it delegated emergency authority to the executive. However, in addition to the broad authority that has been upheld, reviewing courts are reluctant to second guess and give deference to executive when involving foreign affairs or national security. And here the president has acted by declaring a national emergency. As to the nature of the program, indeed, Outbound program involves certain pre-identified sectors which are different from previous use of IEEPA. However, IEEPA has been the primary authority for administration to impose economic sanctions, including blocking new investments in certain countries. And the relationship between investment transactions and national security is not completely unprecedented. Lastly, regarding the recent Supreme Court decision on learning resource overrules tariffs imposed under IEEPA, but I believe that there are some distinction that can be made. And let's move on to the second argument regarding procedural due process claims. As previously discussed, IEEPA's broad authority shapes and sometimes forecloses how courts review challenges to executive actions taken under it. However, a party can still manage to file certain actions, for instance, cases concerning designation under terrorism and economic sanctions. And one area of law that appears both in those IEEPA designation cases and CPS is the use of procedural due process of law under the Fifth Amendment. And under the Fifth Amendment, it requires that no person shall be deprived of life, liberty, or property without due process of law. And the Supreme Court set forth the balancing test in Matthews versus Eldridge. It considered three factors: the private interest and the risk of erroneous deprivation and value of additional safeguards, as well as the government's interest in providing such procedures. The first case I want to introduce is Rouse Corporation versus CVS. This is a 2014 case in the DC Circuit. So in this case, the president blocked an American firm, Rouse Corporation, owned by Chinese nationals, from acquiring a U.S. wind energy farm near a DoD facility. CVS determined that the Rouse acquisition of the wind farm posed a national security threat, and a presidential order directed that the transaction be prohibited. Rouse here challenged the constitutionality of the president's order under the Fifth Amendment due process clause, as it was not offered the opportunity to review or rebut the evidence upon which the CVS and the president relied on. The court here held that a constitutional due process claim to such a presidential actions is reviewable, despite that CVS provides certain president's actions shall not be reviewed, shall not subject to judicial review. And the court recognized its role in reviewing government actions for constitutional violation, and held that president's order deprived Rouse of constitutionally protected property interest without due process of law. Another type of case that challenged the government on constitutional due process ground concerns designation under the sanction regime of IEEPA. So the Ninth Circuit here reviewed such a claim in the case against Treasury in 2012. So the plaintiff here is a foundation, a nonprofit charitable organization based in Oregon, and it was designated by the Office of Foreign Assets Control, or OFAC, as a specially designated global terrorist. This resulted in its assets being frozen. And the court considered two issues: whether OFAC's use of classified information without any disclosure violate, and the failure to provide adequate notice and meaningful opportunity to respond violated the organization's procedural due process. Right. And the court applied the balancing test and held that all three factors support that OFAC violated the foundation's due process rights. The court recognized the government's interest in national security cannot be overstated, but the private party's interests are significant here, and even if OFAC may use classified information during a declared national emergency, it must undertake some reasonable measures to mitigate the potential unfairness to the foundation. And to understand how procedural due process claims may play out in the Outbound program, I want to describe the Treasury's process a little bit here. Unlike CFIUS, the Treasury in the Outbound program does not conduct a case-by-case review of transactions. Instead, the relevant U.S. person undertaking a transactions will need to determine whether the given transaction is prohibited, permissible, but subject to notification, or it's just not covered by the Outbound rules because of other reasons. And also, the program maintains discretion for the Treasury in granting national interest exemptions, where the Secretary may exempt a covered transactions based on the totality of relevant facts and circumstances. But there is no timeline for the agency's internal review and no appeal process or licensing mechanism. In other words, there is not much process for the U.S. person to assess the evidence on which the agency's actions relies on, or more generally, how the agency's determination is made. So I argue that the procedural due process requirements should continue to apply in the Treasury's determinations. And the counter-arguments here would be that there is a risk of exposing sensitive information that could endanger U.S. security, and secrecy in foreign affairs and national security is a substantial government interest. However, as previous designation case shows, there are ways to mitigate the use of classified information, and the government's interest in national security continue to be recognized by courts, and it had been found that it cannot be overstated in a previous case. So to close, I want to briefly summarize where my analysis leaves us. So the Outbound program should not be overturned on the ground that it exceeds the statutory authority, as the President's broad authority under IEEPA has been upheld. However, the procedural due process requirements should continue to apply to Treasury's determinations if challenged, as past cases concerning CBS and IEEPA designation suggest. And this will conclude my presentations. And now I will return.
Okay, thank you, I-Ching. I appreciate that, your wonderful response and presentation here. I'll turn things over now to Daniel Kim to conduct his response to your presentation. Mr. Kim.
Thank you so much, Professor. And first, congratulations to I-Ching. This is really an impressive piece, especially for a 3L. I think when I was in law school, I was still trying to figure out what IEEPA stood for, let alone writing about it. And also to Catholic Law for putting together a great program. It's genuinely encouraging to see students engaging with issues that are not just theoretical. These are questions that are actively being debated in government and in practice right now. So I really enjoyed the paper. It's clear, well-structured. And I thought I-Ching's instinct to focus on due process was exactly right. That's where a lot of the real legal friction is going to be. So what I thought I'd do is just pose a few questions, more as a conversation than critique, and maybe layer in a bit of what we're seeing on the ground in practice. So let me let me start with the foundation of your argument, I-Ching. You do a really nice job walking through the history and structure of the IEEPA, and you come out in a place I think many courts have historically been, which is this is a broad delegation, courts defer, and a substantive challenge is unlikely to succeed. And before I push that on a little bit, I'm curious how you're thinking about recent developments at the Supreme Court level. You've touched on this a little bit, but do you see those as changing the baseline at all for how courts might approach IEEPA going forward?
Yes. Thank you for the questions. I think the Supreme Court's decision on IEEPA tariffs shows that no matter how broad, one can argue that the authority under IEEPA may be, it is not absolute and as it should be. As to how this opinion would affect my analysis and my baseline here, my first reaction would be that it remains largely unaffected because this opinion asks whether the power to regulate importation as granted to the president in IEEPA authorities covers the power to impose tariffs. As the majority answers, it does not. So I believe that this case focused on the distinctiveness of tariffs rather than setting the boundaries of the president's authority under IEEPA. For example, it starts with the Constitution's layout. The Congress shall have the power to lay and collect taxes. It also notes the revenue-raising feature of tariffs as a distinct feature of taxing power, and that none of the IEEPA authorities involve the power to raise revenue. So I believe this case shows that yes, the IEEPA authorities is broad, but tariff is really distinct from all the authorities that in regulation in this area.
Yeah, I think that's exactly where most people start. Like courts, as you've noted, I-Ching, have historically been very deferential in this space. I guess the question that crossed my mind reading your piece was whether that baselines is starting to shift even slightly. Not necessarily that courts will stop deferring, but that they may be a bit more attentive to statutory text, the scope of delegated authority, and maybe the economic significance of what the government is doing. So I was wondering how you think about that tension between historical deference and what might be slightly more, how to put it, like text-driven approach today. So let me shift to something I found also really interesting in your framing. The paper treats the Outbound program as broadly consistent with with prior IEEPA tools, things like sanctions, blocking actions, and like transaction restrictions. And that makes sense at a high level, but I wanted to ask, stepping back a little bit, whether you think this program might be doing something slightly different in kind. If you think about it, this program is sector-wide and forward-looking in some respects, and not tied to specific bad actors, as is the case for economic sanctions administered by OFAC, and aimed at shaping how capital flows over time. So to me, that feels a little different from don't transact with this designated entity. So do you think a court might see that difference as meaningful?
Yes. I think like my first reaction would be that yes, this outbound investment security program is different from the previous use of IEEPAs, such as those economic sanctions, as you mentioned. Those sanction regimes involve like a designation, like the government identify these entities that the U.S. person should not be engaged with. However, I also find that the Outbound Investment Security Program still limited in the way that it clearly identifies certain benchmarks as for the cover transactions, and it targets investments to the country of concern. So it will be a little bit hard to argue that it's a broad economic policy making that the U.S. government want to restrict its overall outbound investment right now. So I think the way the outbound program frames its cover transactions and target at the countries of concerns, still providing some limitation, trying to make this program more targeted, similar to those sanction regimes. And as to the previous IEEPA, to my knowledge, it is also used to maintain a dual-use export control system when the underlying authority has lapsed. So I think there's still an argument to argue that the Outbound Investment Security Program is still limited and targeted and make it closer to the previous sanction regimes. That's my first response.
Yeah, I think that's a very fair way to see it, and certainly how the government would frame it. What's interesting from a practice perspective is that clients don't really experience this like sanctions. With sanctions, it's usually avoid that person, avoid that entity. Here, it's more like we need to rethink categories of investment across sectors. So, and so I sometimes wonder whether a court might look at that. This is less about blocking bad actors and more about steering economic activity. So it may not matter legally, but it does feel like a slightly different animal. And again, I don't think it necessarily changes your conclusion, and it might be worth acknowledging that the analogy to sanctions, while helpful, may not be perfect. So, and let me turn to what I thought was the strongest part of your paper, the due process discussion. You walk through case law, the OFAC cases, the use of classified information, and I thought that was really, really well done. One thing I was curious about, and this is maybe just layering on, is how you're thinking about the role of the APA here. Do you see due process as the primary path for challenges, or do you think APA review might end up doing a lot of the work?
Yes. So from my reading of the Ninth Circuit cases in designation, so that case shows that APA still plays an important role in for the court to review the substance evidence for the designation and the redesignation in that case. And the court in that case actually found that the government, there is substantial evidence to support government's action of redesignated that foundation as terrorist. So I believe APA still play a role in this type of cases. And the reason that I move on to the discussion of constitutional due process rights, it's from reading that cases, I feel that the courts is still fairly not really, but fairly deferential to the government when reviewing the evidence under the APA. And it applies a different test, seems to be more not friendly, but more, I would just say friendly to the plaintiff about using classified information here. So that's why I focus my paper on the constitutional due process grounds, but of course, because agency actions generally is subject to the APA. So yes, APA will still plays a role if the outbound program get challenged in the court in the future.
Yeah, I think that's exactly right. They tend to overlap. The only reason I raised it is in practice, courts often prefer to resolve cases on APA grounds first. So instead of saying this violates due process, they'll say the agency didn't adequately explain its reasoning. So, and when I was reading your paper, I kept thinking, this program has a lot of features that courts typically focus on in APA cases, like broad discretion and limited procedural guardrails, not a lot of transparency, and no clear standards in some areas. So I wondered whether one way to strengthen your argument is to say, this isn't just a due process issue. It's also a classic administrative law issue. So, and from a client perspective, that's actually how people think about it. They're not asking, is this unconstitutional? They're basically asking, if Treasury makes a decision we don't like, can we challenge it in a meaningful way? So that's where I was coming from. And my final question, and let me drill down a bit on Treasury's role, because I think this is where your paper really hits something important. You describe national interest exemptions, accepted transactions, and decisions based on totality of the circumstances. And you note correctly that there is no timeline, no appeal mechanism, and limited guidance. I was wondering how do you think courts will react if a party comes in and says, we sought an exemption, we were denied, we don't know why, and we had no real opportunity to respond?
Yes. I think as you mentioned that the courts will tend to start with the APA to see if the government has at least established a record of evidence to show that to show the government's reasoning of these decisions. So I think the government will need to show a record of how it decides whether to grant a accepted transaction or a national interest exemptions. And yes, I can see that the Treasury enjoys a great deal of discretion from its final rules. Like it reiterated that its decision will based on the totality of relevant facts and circumstances, which from the perspective of a private party, that basically says like we don't know the standard and we cannot expect whether the Treasury will grant this exemption or not. So I think that's also the reason that I focus on the due process aspect of a potential judicial review for this program.
Yeah, I think your paper had the right instinct there. Courts will be very careful not to intrude on national security decision making, but at the same time, courts usually want to see some evidence of reasoned decision making. And from a practice standpoint, this is really where the concern is. Clients are less worried about, does this program exist? And they're more worried about how predictable is Treasury's decision making. For example, if we apply for an exemption, what are our chances? And what factors actually matter? And will similar cases be treated similarly? And as you know, lawyers love predictability, or at least the illusion of it. So I think your instinct is exactly right. The real pressure point here is not the existence of the program, it's how it's implemented. I guess I'll stop there. But again, really impressive work. These are not easy questions, and I think you've done a excellent job framing them in a way that is both doctrinally grounded and very relevant to what's happening right now. And I'll just say, if you're interested in this space, you picked a good time. We are all still figuring it out too. Yeah, thanks again. Really enjoyed it. Thank you.
Thank you, Daniel Kim, and thank you, I-Ching. I will open the floor up for any questions from the audience for I-Ching and Daniel to both respond, as y'all can both jump in and help out on any responses. If you just raise your hand. Professor Pollinen has a question. John, you just make sure that your microphone is on and fire away.
Thank you, Professor Harmon, I-Ching. Congratulations on having the courage to address a very complex topic so clearly and logically. More a comment, really, in my career as a lawyer for several foreign banking institutions, I remember how concerned we were when we had to advise our proprietary trading desk about the requirements to get approval from CFIUS for certain financial investments. And so we ended up building in pre-approval requirements, early warning thresholds, and some absolute ceilings so that we just didn't need to ask for an exemption or try to fit within an exception. It was just easier from a compliance perspective to avoid the issue. It might limit some of our investment opportunities, but that was a few years ago, as you might guess. So I'm wondering now if you have any advice, or maybe Daniel does, on clients who are confronting inbound and outbound restrictions on what sort of a compliance program we should have. Is it still good enough to have early warning and position monitoring and pre-approval requirements, or should we consider anything else?
I can start. So from a compliance perspective, so as Daniel and I just mentioned that these outbound programs provide certain benchmarks for the U.S. person to be more like self-compliance, like you need to follow the rules, like to decide if your proposed transactions meet certain requirements. So I think from the compliance perspective, that's definitely something a company would need to look into to see if any potential investments fell into the scope of corporate transactions. And this is my first reaction to that.
Thank you. So it sounds like we would need to make sure that our screening process is robust to pick up any potential issues before the investments are made, and probably some training programs for the investment bankers before they go out and try to arrange these transactions. I see Daniel is nodding. Thank you.
Daniel, can you expand on any of that, or would you like to contribute anything to I-Ching's response on that?
No, it's a great question, and I echo everything I-Ching said, and this is actually the one we are getting a lot right now. I'd say the first thing is this doesn't really require reinventing the wheel. Most companies don't really need an entirely new compliance program. They just need to adapt and integrate these issues into frameworks they already have. So I think the most important principle is to keep it risk-based. Not every company needs a heavy, standalone outbound investment compliance program. The level of structure should match where they operate and what sectors they're in, and whether they have exposure to higher risk jurisdictions. So I guess the first step is really just understanding, do we actually have exposure here and where? And I guess, and also the most valuable part of a compliance program here is actually at the front end. You want the process where early in a deal or investment, someone is asking, is there a nexus to sensitive technology or sectors? Or is there a country of concern angle? Or does this raise a notification or prohibition issue? And if you catch it early, most problems become manageable. And if you catch it late, it becomes much harder. And finally, I would just note that this is an evolving area, as I-Ching's paper captures well. The rules are new, guidance is still developing, and enforcement patterns are honestly not fully clear yet. So whatever program a company builds should be first flexible, and second capable of being updated and not overly rigid. So in short, keep it risk-based, integrate it into what you already have, and focus on early issue spotting, and just avoid overcomplicating it.
Thank you to Daniel and to I-Ching. That sounds quite consistent with the risk-based approach that most large, complex organizations are taking anyway to compliance in general. So I like the integrated model, which should be good for most companies in multiple lines of business. So thank you. That makes sense.
Any other questions? I'm going to pose one myself. Maybe Daniel, you could help us out here. You've seen that I-Ching is very capable, very competent, and she's this is a very ambitious project, and I think you praised her on her bravery to take on something so vast. What would you suggest would be the next paper she should write? What would be the next thing that she should, given what she's looking into now, what should she go into next? What area should she, what is rife for her next scholarly endeavor?
You know what? I thought this paper, I mean, given her very interesting background, I think this paper was a rare combination of her analytical strength and her background, and where lots of actions are taking place right now. Maybe with the new development, with the passage of 2026 NDAA, the Coins Act, maybe she can endeavor to write on like Outbound Investment 2.0, or she touched on this in her paper, but something about CFIUS. It's, as I-Ching already very well knows, it's a very vibrant area, and CFIUS, and we get lots of questions from clients on sanctions and export controls issue with the U.S.-China rivalry deepened. So these are all potential areas I see I-Ching drafts excellent papers, and I'd love to continue to be her first reviewer.
Thank you.
I-Ching, I hope that you will take up the gauntlet and write another work in this line, because I think it is a strength of yours, and as Daniel has pointed out, you're in a unique position to make these points. You're positioned well, and I think he'd be a great mentor for you in getting these things placed and have an audience for them, because it's an important discussion to have, and it's important enterprise to take on. We are now drawing to a close. If there are not any other questions, I know everybody's got to get on to class and get on to other things they've got to do this afternoon. But I just wanted to thank Daniel Kim, particularly for taking time out of his busy day to respond, and to I-Ching for her very ambitious and wonderful presentation to end out this year's Student Scholar Series. So thank you all for coming, and we will start again next year in the spring with I don't think this is our 18th year of these things coming up. So thank you very much. Goodbye.
Well done. Well done.
Thank you.
Very good.